The views and opinions expressed in these radio programs are those of the individual hosts and do not reflect the official policy or position of Universal Broadcasting Network. Welcome to the National Safe Child Show, addressing the health, welfare, and safety of all children nationwide, because it shouldn't hurt to be a child. Here are your hosts, Tammy Stefano and Priscilla Perez.
Hi, everybody. We're so pleased to have you today, and especially pleased to have a wonderful gentleman who's making a difference in society, and his voice is so very important to the domestic violence issues that this country and the world is facing. The Honorable Eugene Hyman, welcome.
Thank you.
Welcome. Thank you so much, and we're truly grateful that you are here.
Thank you for inviting me.
So we had a great opportunity to discuss so many issues before the show, and Eugene honestly is a wealth of information. So where should we begin?
Well, first I better tell the audience I'm retired.
Yes.
And that's very important.
Absolutely.
because I'm allowed to express my personal opinion about anything we talk about, whereas if I were still an active judge, then I would be limited by the canons of ethics in terms of the importance of remaining fair and being perceived as being fair, neutral, and impartial. Now that I'm retired, I'm allowed to express my personal opinion, and that's what I'll be doing here today.
And now he can be unfair and very partial.
I certainly am concerned about, the issues of domestic violence are very important to me. They were part of my life for 20 years as a judge. That's right. And I have strong feelings, and many times I had to be very careful how I express those. Rightfully so, because if you're appearing in front of a judge, you want he or she to be fair, neutral, and impartial, and you want them to be perceived as being fair, neutral, and impartial. And now I'm allowed to express my personal opinions, and the Code of Judicial Ethics is not binding on me.
Which is wonderful, because we desperately need you.
We need your opinion.
Yes.
We really want to know how you feel about domestic violence and how these issues pertain to a lot of the legalities, pertaining to a lot of these cases.
And I'll tell you to the extent, the extent that I know.
That's right. And he knows quite a bit. So where do we begin? Okay. Right now, we're in a system that, in your opinion, is handling domestic violence how?
Well, it depends so much where you are in the United States. And, decisions are made at a community level. In California, you have 58 counties. To a certain extent, you may have 58 different ways of doing things. Now, you certainly have a law or the law that is applicable in all 58 counties. You have statutory law, you have case law, but you have 58 potential different ways of how things are done with respect to, let's say hypothetically, someone is found guilty or pleads guilty to a domestic violence related offense, how much time they're going to receive. There are standard conditions of probation that are required if a person is given probation, including the 1-year intervention program. But in terms of those intervention programs, what they're like in those 58 counties, to a certain extent, there's slight or maybe even great differences because of the available resources in those 58 counties. Whether those counties are rural or whether those counties are urban makes a big difference. Whether the judges are trained makes a big difference. Whether the advocates are actively involved in those communities, what the resources are for victims. These things are huge in terms of outcomes. And the more under-resourced the community is, the more difficulties there are for those that are surviving domestic violence. The more resources and the better trained everyone is, then at least hopefully there's better outcomes. And that's one of the things that's so frustrating is that you talk about domestic violence issues at conferences or at programs such as this, and people want to know, well, what can we expect in terms of an outcome? And all I can do is talk in terms of generalities because I don't know everyone's community.
Of course.
And in terms of and how they do things. Decision making is a very interesting aspect of judging and how decisions are made. I mean, even if we're talking about something as potentially simple as child custody, which is a computer program in terms of you look at the spouses, what their income is, what the timeshare is. You enter all this in, and it tells you what the child support is going to be. But then you have little nuances in terms of differences. For example, in Santa Clara County, where I was, if you had a midweek visit, then whether or not you got credit for that visit in terms of reduction of support depended upon whether or not you fed the child.
Right.
And so we almost called it the Happy Meal provision. So if the child was fed, whether it was fast food or at home, then that parent got credit for that visit in terms of a slight reduction in child support. With respect to spousal support, you have nuances in communities versus communities in terms of the kinds of considerations that are taking in terms of how that's awarded. With respect to child care costs, with respect to, everything to do with everything has local nuances. And that's why it's so important, if at all humanly possible, to have an attorney. And if you can't have an attorney, which 70% of the people in family court don't because they're expensive and they're especially if you've separated and you have two separate households, it gets very expensive. But you have to know your judge to the extent that you can know he or she that you're appearing in front of, so you have some sense in terms of the kinds of things that are important to them.
Right.
In terms of trying to give them information to make these important decisions. But without sitting there or doing some research on a particular judge, you're flying blind. One of the reasons for hiring an attorney is hopefully the attorney knows the person that he or she is appearing in front of. When I first became a lawyer in 1979, it wasn't uncommon for judges to, for lawyers to go to multiple counties. Now, if I were a client, I would want, if at all humanly possible, the exception being in the real northern rural areas of the state, you want a lawyer who spends the majority of his or her time in front of the judges that your case is in front of, so they knew the nuances in terms of how this person thinks.
Right.
I mean, a good lawyer is able to predict with a certain degree of certainty what the outcome's going to be. And I think it's important as a judge to let the lawyers know how you make decisions, because you want them to be able to anticipate you. Number one, it gives confidence in terms of judgments and verdicts, and also it encourages settlement. I mean, if the lawyers have a pretty good idea what you're going to do, they're able to tell their clients, they're able to talk to one another, and hopefully they're able to resolve their case. And in family especially, things go better when the parties resolve their case than when the judge resolves it. Because if the parties have participated, then they have buy-in. They also have more confidence in it. I mean, if a cold, neutral adjudicator is making these decisions, then they kind of, did he really she really understand my issues? Did they really understand the evidence from my viewpoint? And that's part of the confidence level that you try to give parties that are appearing in front of them. One of the things that you can do is to paraphrase back what you've heard to make sure that you did in fact hear their evidence. And then the other thing you can do that's helpful is to explain your decision-making process. They can disagree with it. They may not be happy with the outcome, but hopefully everyone that appears in any court is confident that the person listened to them and heard what they had to say, and then applied the facts as they determined them to be to the law as consistently as is humanly possible.
You're one of the few. I've sat in so many courtrooms and have been a witness to hear cases, kind of a court watch, if you will. And there's very few judges that I have seen that repeat to make sure that he's understanding correctly. You're one of the few.
Well, thank you.
I
haven't appeared in front of other judges, let's say in family court. Number one, that wasn't an area of law that I practiced when I was practicing law.
Right.
And two, as a judge, I certainly didn't have the opportunity to observe other judges in terms of how they did things. But this was something that I started hearing occasionally. Someone would complain, you didn't hear me.
Right.
And so to make sure that they knew that at least I heard them,
right,
whether they agreed with the decision or not, because it's very important. I mean, it goes back to childhood. I mean, if your parents are giving you punishment, or they're not letting you go out with your friends or whatever, you at least, how many parents say, look, I'm the parent, this is the order, and you have to carry it out.
Right.
I think it's a lot more helpful if a child at least has a little bit of an understanding in terms of the thought process. They can disagree with it, but I always felt better when I understood why my parents were doing what they're doing.
That's
now,
right.
every once in a while, they said, this is what I'm doing, and this is it. And
there's no
this is the way it goes.
This is the way it goes, and you don't get to question my judgment.
Yes.
And, okay, they're parents. But I think in terms of judges, the thing is, though, that judges are really stretched for time, and it is a little time consuming
right.
to do all this explaining. But the thing, even in criminal, I found that I think it's beneficial when you're giving a sentence, whether it's based upon someone has pled guilty or no contest to an offense, or they were found guilty by a jury, to let them know, hey, you're getting 18, 20 years, and this is the reason why.
Right.
Again, you can disagree, but I've given thought to the probation officer's report. I've given thought in terms of what your attorneys had to say, what the DAs had to say, and I think that the situation requires that I do this, and this is what I'm doing. That also assists the appellate court in terms of deciding whether I made a mistake or not, because maybe I considered a fact in a way that I'm not allowed to consider it. And I would be disingenuous to say that in 20 years of judging, I never got reversed. we all make mistakes. The good news about judging is compared to sometimes in comparison to medical care is that when a judge makes a mistake, hopefully it's corrected. When you make a mistake with respect to the wrong leg or wrong arm, it's a little tough.
Right.
That's right. That's right. There is, gosh, we have lots going on here in the chat room. Yeah, you're watching, John, huh? Yeah, there's lots of action. I can't seem to make mine bigger. I don't know if you can help me. Yeah. So a lot of people say when they go before a judge in family law, they are presenting their case. You made a comment earlier, and I'm not quoting you, but it was something similar to. There is a type of direction that seems to be prevalent with when a domestic violence case is brought before the court. Can you talk about that?
Well, again, it depends upon the community that you're in terms of how these cases are viewed. And some communities or some counties there can be differences. Los Angeles County is so incredibly large that, if you're in Pomona, it might be slightly different than downtown LA, or it might be different in Lancaster, or the most northern part of the county. In an ideal world, everything would be the same, but that isn't reality, because you have local differences. But in an ideal world also, people understand that when you appear in front of a judge needs the information, and it has to be, this is really tough for people representing themselves, because they don't understand concepts of hearsay, concepts of best evidence, concepts of foundation in terms of how getting evidence in, and they want to make sure that the trier of fact, because remember, please, in family court, there are no juries.
Yes.
The judge is the decision maker, and so that's the person you're trying to influence, and rightfully so. And as a result, you're trying to influence the outcome, hopefully ruling in your favor, and you're trying to get in what you think is favorable information, and it may not be admissible for a number of different reasons, and that's very frustrating to the party. Mm-hmm. And I certainly understand that, and judges certainly understand that. But actually, in recent years, the Judicial Council has passed rules of court that allow judges in certain assignments to be a little bit more proactive and not to be in violation of the canons, because, and let's say if this were a criminal case, you couldn't be as active. Family law is one of those situations where the judge, let's say, especially in a situation of child care, or custody or visitation or access, where the judge can be a little bit more proactive in terms of asking questions of the parties.
Okay.
Whereas if in a different division of the court that might, especially criminal, where the burden is on the district attorney to prove the case, then a judge, even a judge that's hearing a case, really has to be careful in terms of what the questioning is and how much, etc. Because again, it's a perception issue that the judge is not another prosecutor.
Absolutely.
But in family
and what
court,
if a judge does go over that line? I'm looking. There's lots going on here, lots of chatter, and I'm not going to mention the judge's name. But there is a judge up north. Allegations of sexual abuse, severe domestic violence.
By the judge?
No. No. Between mom and dad.
Right.
There's a divorce.
Right.
Mom is so fearful. She goes to court seeking some help here.
Right.
And some protection for her and the children. Right. None is offered for whatever reasons, whether she didn't present, whether she didn't have representation. It wasn't admissible evidence. She becomes so fearful that she leaves. She flees with the children. Prior to
in violation of a court order?
Well, judges...
You got to be very careful about that.
Right.
In other words, if there's a child custody order, you just can't...
pick up and go.
You can't, because then you're potentially facing child abduction
charges. Absolutely. And this is, I believe, what happened here. So 2 judges, prior to the 3rd judge coming on, protected the children and the mom. They saw this very clearly. There wasn't any question. There was substantiations of physical and sexual abuse, protective orders for DV, father sexually assaulted. It was substantiated. Drug convictions on father had drug convictions under his belt. And this new judge comes on board. Now, oddly enough, behind the scenes, I had some conversation with some insiders regarding this particular judge, and the insider said he was such a crappy attorney, such an arrogant attorney, and just thought that he was above the law, that we actually helped to get him in that judicial seat because our thought was, if he gets in this seat, damn it, he's going to have to follow some laws. And what he did was he displayed the same characteristics as when he was an attorney, unfortunately. And now they're kicking themselves in the butts. And here he is. And you said something earlier that they can be more proactive now. Well, certainly in this particular case, this judge is more proactive. He's actually stated while sitting on the bench that he's doing his own investigations.
No.
Right, and he can't.
No, a judge cannot.
He cannot.
A judge can, I think, say to the parties, this is information that would be helpful to me, and then tell them what information you would like them to gather.
Right.
But no, a judge is not an investigator. Now, the larger question that you're asking is, what do you do if you appear in front of a judge that you think is not being fair, neutral, and impartial? There's several potential things that you can do. One is that you can lodge a complaint with the presiding judge of the entire court. That is, you can write a letter to... Now, Los Angeles County, you've got almost 1,800 judges, but still, even in Los Angeles County, you can write a letter to the presiding judge, and the presiding judge will investigate to a certain extent, but the presiding judge is not going to interfere with a decision that is a lawful decision. Now, if there was some kind of irregularities that went on, then maybe, depending upon what those were.
With that particular case or with that particular judge?
Well, both.
Okay.
The other thing you can do in the future is you can file an affidavit, which each side gets one affidavit
without prejudice.
Without prejudice of their case, to remove that particular judge from their case.
Okay.
The other thing you can do is find a candidate who's willing to run against that judge when they're up for re-election every 6 years. The other thing you can do is make a complaint to the Commission on Judicial Performance, which does not discipline judges for lawful decisions that maybe reached a bad result. They are only interested in behavior.
Right.
And of course, the decision can be appealed. That said, I recognize that it's very expensive and it's extremely difficult to do, especially if you're doing it yourself,
Right.
because you have to be able to file a brief and the like, and it's even more expensive on an appeal than it is in terms of the underlying case. So the reality is most people can't afford to appeal a decision.
Right. Do you think the system is set up like that in a sense?
No, I really don't.
Okay.
It's just, see, if you're in a criminal case,
Okay.
by law in California, it's not necessarily the same nationwide, but in California, if you're convicted, you get the right of an appeal, and if you're indigent, you get the right of an attorney, a free transcript, and everything else.
Right.
Family law, we don't have what's referred to as a civil Gideon,
Right.
which is one of, I think, the shortcomings of our legal system, is that in an ideal world, people who were working poor, and who qualified would be able to get an attorney to at least give them advice, even if not to represent them. And there is, certainly in most counties, there is low cost, low fee legal aid, something,
Right.
in terms of a help. And a lot of courts have help
centers. Yeah.
Now, they're
Legal.
not, but for a court to provide that, to be very careful, because they're helping you fill out forms, but they're not giving you advice. They
Right.
can't.
They can't give legal advice.
No, they can't,
Right.
because ultimately it's the system that's going to be making a judgment or making a decision. So the help
Right.
centers are not the judges, of course. They're lawyers that are helping, that are work for the court, that are helping to fill out the paperwork. So there are things that can be done, but when you're talking about trying to change something that's already happened, that becomes very difficult. But on the other hand, child custody decisions are based upon, if there's subsequent decisions, are based upon a change in circumstances.
Right.
So what has happened, and let's say hypothetically you get a decision that you think is unfair, after a passage of time, if you're able to demonstrate that the child is being adversely affected as a result of this, then you can petition again on the basis of a change in circumstances and have the case re-examined. And then the other thing that's important is in terms of evaluators. And this, again, with the economy, it presents problems because ideally, if you can afford your own evaluators, then you get an evaluator, the other side gets an evaluator, and then if you have to have a contested hearing, then the judge will decide which evaluator to give weight to and which one not to, and the judge has to articulate reasons in terms of why he or she is giving weight to one and not to the other, or maybe to neither. Then the court system has its own evaluators. They're referred to as family court evaluators that are actually employees of the court. And they do a great job. The problem is there's too few of them,
Right.
and they aren't able to spend hours and hours. I mean, they have to get a snapshot view of what's going on,
Right.
and make a recommendation to the court, and the court is free to adopt their recommendation as orders, or to tweak it, or to do whatever they think is appropriate based upon the totality of the evidence. Because a judge might decide that an evaluator, whether the court's evaluator or private evaluators, that they don't agree.
Right. I think we have a caller.
Yes, we have a caller.
Yes, hi. Thank you so much.
Caller, before you ask the question, because sometimes callers take quite a while, we're limiting our calling questions. We want to get the most we can out of Mr. Hyman, so please, 5 minutes.
Understood. Okay. Judge Hyman, my question is this. I actually have a case right now in the San Fernando Valley, and in 2010, I lost complete custody of my child. At that time, she was 7.5 years old, and it came swiftly after she had disclosed sexual and physical abuse by her biological father. I also would like to add that until she was 7.5 years old, I had almost, I would say 95% custody, and there were allegations that I was emotionally abusive, and that I was alienating, and that I was a potential slight risk.
What is the question? What is the question?
My question is this. I've been on supervised visitation for 2 years now with no incident. Everything is going very well. I just want to know, how is it even possible? I mean, how can
can you get custody?
Right, how can this be? I mean, is this going to stay like this forever? She's 9 years old. I mean, I see all these other people that are going through this for so long, and
with no resolve, in other words.
Right.
Okay.
Is there a way to resolve it? And I'm so grateful to be able to ask you.
Well, I want to be careful that I'm not giving legal advice. I'm talking in a hypothetical situation. As I mentioned earlier, child custody decisions are not permanent. I mean, the only child custody decision that would be permanent is if you were in the abuse and neglect system, which is dependency, and if the court were to terminate parental rights, that's permanent. Anything else the court does until the child becomes 18 can be modified, and it can be modified based upon what's referred to as a change in circumstances. So hypothetically, if a person is having supervised visits over a period of time, there's no problems with those visits, and the people that are observing those visits are witnesses in terms of how the people are behaving, etc., then potentially the person who's being supervised can petition the court under a theory of change in circumstances for modification. That modification might be to have visits without supervision, and it could be all the way up to requesting that custody change back to what it was previously. That probably is going to take a fair amount of independent evidence. In other words, you probably would expect that there would be a child evaluation in terms of talking to the child, talking to the parents, talking to the people that are doing the supervision, and getting a sense in terms of what all these experts have to say, and even people that are not experts in terms of their observations. And then the judge would make a decision based upon the evidence in terms of whether or not there was a change in circumstances. And remember, all these decisions are based upon what's in the best interest of the child, not what's in the best interest of the parents, but what's in the best interest of the child in terms of keeping this child safe and happy and moving forward. So each case is individual, it's different, and I guess the only thing I can say is it depends, which never makes anyone happy in terms of an answer, but it truly is the answer. It depends upon the evidence. But there's always something that's possible based upon the evidence and based upon a potential change in circumstances.
Thank you, caller. I hope this was helpful. Thank you for calling.
Thank you so much. Bye-bye.
Bye.
So, best interests.
I knew you were going to ask that.
This is the
language.
Popular.
Well, it's been since the history of time.
Yes.
And now what the best interest of the child has evolved over the years. It used to be there was the doctrine of tender years. So if you had a child, below school age, the rebuttable presumption, although it wasn't actually a law, but this has to do with a cultural understanding, although it was a universal cultural understanding, is that children are better off during the tender years with the mother.
Right.
And that certainly is true if they're really young and they're being nursed and things of that nature. And the courts said, no, you can't assume that because the child is very young, that means automatically the child goes to the mother. Well, in 99% of the cases, a child under the age of 5 is probably, assuming that the mother is safe, the child is probably going to be going to the mother, but it can't automatically be done because of tender years.
Just because,
And the viewpoint, because of equality, and I think this is a good thing, is that the view now is that both parents are capable of being appropriate and good parents. Obviously, whether they are or aren't will be determined by the evidence. So there's no longer an informal presumption that automatically young children go to the mother over the father. the best interest has been the standard since the history of time in terms of making these kinds of decisions. And the other thing that we now, of course, have a better understanding of child developmental issues. So when we talk about child development, we're talking about not only domestic violence, but in terms of how children perceive adversity. Right. To a certain extent is dependent upon their age and dependent upon how they've developed. And as you know, children, there are certain marks of certain ages in terms of expectations, and sometimes children are more mature than the average child for that age. Sometimes they're less. Sometimes they have more difficulties. Then we have the other issues of learning challenges and dyslexia, ADD, ADHD, and all the host of different kinds of initials with respect to diagnosis. And so the issue might be, okay, which parent is going to get better for this child in terms of making sure that this child gets the assistance in school that they need, making sure the child takes the medication that they need. Right. So it becomes quite complex in terms of the assessment. It isn't just who's going to feed the child, clothe the child, take the child to school. It's who's going to make sure all this other stuff happens. Who's going to advocate for the child with respect to the school, or who's going to be a better advocate for the child? Right. Who's going to be better with respect to extracurricular activities, with respect to religious activities? I mean,
is there some kind of a list? I've always wondered, and I've been told, you hear these little, there's no list where you say, here is kind of this generic list for you to look at in making these decisions, because your best interests theory or standards might be very different. Right. We might have different beliefs, religious beliefs. Now we're both sitting on the bench, and I have these two litigants before, and I might think differently.
Of course. No, there isn't the generic list. Every child is unique in that sense, and every child has its own list in terms of needs. Right. And with respect to religion, the parent that's the primary parent gets to dictate with respect to the religious beliefs. Okay.
Primary being most of the custody.
Most of the time.
Right. Okay.
Remember, there's different. With respect to the award of child custody, there's legal, physical custody. Right. Even if all of 100% of the legal physical custody is granted to one parent, that doesn't mean that the other parent doesn't get visitation. Right. It just means that the parent that, in terms of custody, you can have sole legal physical custody, you can have joint physical legal custody. Right. And in the case of domestic violence, by statute, it's a rebuttable presumption. But the rebuttable presumption is, in California and in most states, not all, but most, that if there's domestic violence, then legal physical custody will be awarded to the non-battering parent. The reason for that is so that the battering parent doesn't have the ability to control the other parent through the child because of these child rearing issues. Mm-hmm. If the total authority goes to the non-battering parent, then the battering parent doesn't have this as a mechanism for control. Again, it doesn't mean that that parent doesn't get visitation, but it does mean that that parent doesn't get to control the medical questions, the school questions, the extracurricular questions, the religious questions. That person doesn't get to make any decisions over those issues. That person can be involved with respect to meeting with the guidance counselor, but that person meets separately from the victim. Right. And that person certainly is able to express opinions, but that person has no say.
Right.
So that's what's evolved.
Good job.
I don't know. I'm just listening because he's looking for
it's
information.
Amazing. I know. Hearing you right now, everything sounds so perfect. And it sounds, not only does it sound perfect and logical and very workable and solution-based, most of what you're saying actually is law.
It is, but remember, we're talking hypothetical here.
Right. This is a hypothetical, but however, there is a 5-year legal standing, for lack of better words, where two litigants come before a judge. If there was domestic violence that was established within the 5-year period, that child's not going to go with that person because.
Right.
But I'm seeing it happen over and over again. It's being ignored.
Well, okay. That speaks to the importance of appeal. And there's in Northern California there's an appellate project where they're actually appealing cases where judges have made what they feel to be inappropriate rulings based on the law. So, for example, where there is a rebuttable presumption, the judge doesn't follow the presumption. So they're appealing those kinds of cases. Technically, a DA can appeal a case where under 1203.097 of the Penal Code, it says if you grant probation in a domestic violence case, you must do these things. And sometimes